right. So, Mr. Boyd, in cause number 26, DCCR 0227, the state has elected to proceed on a lesser included offense of a driving while intoxicated second. And that's from November 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with?
Yes.
And then the indictment further alleges that you were previously convicted of driving while intoxicated February 9th of 1984. And is that true or not true?
Yeah.
True or not true?
True.
And I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Mitchell? The papers on the tablet, did you go over those with Mr. Mitchell?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, you.
And it looks like the agreement that you've reached is for a 1-year term in the county jail, but that would be probated. You'd be on probation for 2 years.
This hearing focused on a second DWI, driving while intoxicated case involving Mr. Boyd. After pleading guilty to the offense from November 2025, Judge West accepted a negotiated plea agreement. Instead of serving a full year in county jail, he received a 1-year sentence that was probated for 2 years, meaning he can remain out of jail as long as he follows every condition of his probation. The sentence also included a $4,000 fine, the mandatory use of an ignition interlock or alcohol monitoring device, and 3 days in county jail beginning Friday evening. Before ending the hearing, Judge West gave a clear warning: report to jail on time and do not arrive under the influence of alcohol. With the sentence finalized, the courtroom immediately shifted to a separate legal dispute involving another attorney challenging a previous sentence as unlawful. Even with probation, one mistake could send Mr. Boyd back to jail to serve the full sentence.
He would be required to have the ignition interlock device for that entire probation period,
Yes.
As well as paying a $4,000 fine. And in addition to that, there is no waiver of the state DWI super fine. That's something with you and the state. Do you understand?
Yes.
And then judges,
State would request that certified.
All right. Thank you.
and right now he has the handheld blower. He does not have a vehicle that he's driving. So he does have that.
Okay. So if you're not driving,
Yes.
you cannot drive any vehicle unless it has that auto ignition interlock device.
Yes.
If you're not driving, then part of your probation would be to keep that handheld the entire time as well. All right. And you're a U.S. citizen, correct?
Yes.
State tenders number 1.
No, Judge.
It's admitted. Any evidence that Mr. Boyd is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor, driving while intoxicated second. Sentence you in accordance with your agreement to a term of a year in the Jefferson County Jail, but probate that. You'll be on probation for 2 years. You're ordered to pay the $4,000 fine, and so with the DWI second, it's 3 days. So there's a requirement of 3 days in the Jefferson County Jail. By law, are you working?
Not much.
So what I'm going to do then, Mr. Boyd, is order that you serve those 3 days starting this weekend. So you will report to the Jefferson County Jail Friday at 6 p.m. You're going to serve 3 days. So you'll get out on Monday. That way you get it all taken care of at one time. It's very important that you are on time, be at our jail at 6 o'clock, no later. Also, it's obviously very important that you show up not intoxicated or anything like that. Some people think it's a great idea to show up and, sleep it off. Don't do that. If you're late, if you don't show up, that's a violation of your probation and you'll be right back in court. Do you understand?
Yes.
Also, I'm ordering that, again, the state's super fee is not waived. The state has requested that, and so it will not be waived. I'm going to hand you second the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal.
Yeah.
It's coming. Anything else I need to I think I said it all. Yeah, make sure you go ahead. If you don't have the attachment, And Mr. Mitchell, you can either email today the attachment, or if you want to handwrite it on something, what you looked at, you can do that as well. But we need it today before we close out the case.
That's fine. I can call Mackenzie real quick and have her send it over.
Perfect. If they'll email it to Ms. Holmes, that'd be great. All right, here's that trial court certification. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork, and she's sitting right behind you. So watch for her to call you up, okay? And again, make sure 6 o'clock this Friday, which is the 20. What's the Friday?
Does he need anything to get in, Judge?
Here, I don't think so.
Okay.
It'll be there.
Okay.
All right. Thank you.
Judge, I'm going to take him out in the hallway for just a second, and I'll go right back in.
Okay, thanks. Kimler, I don't see that you have filed anything that I requested get filed before today.
I didn't understand why I have to file a writ. I mean, it was an illegal sentence. I mean, she never should have received the sentence. They couldn't, the court have the power to vacate the sentence.
No, I don't, without a motion.
I did. I filed a motion to vacate the sentence. Yes.
I don't see it.
That's how it's come to our question.
It's not.
I think there was a motion.
It's not a quash. That's not. And that's why I sent you. And I talked to Mr. Florence, and you said that you were going to talk to Mr. Florence. And we did all the research, and I've done all the work for you, which is very frustrating.
All the work I filed a writ
Before today. And I mean, literally 3 days after court, I handed you on a silver platter, here's what you need to file. You emailed back that you would talk to Mr. Florence if you had any questions and get it filed. So today, what can happen is if you would like to make an oral motion for me to vacate all of the proceedings, I would entertain that oral motion.
Yes, and I think I filed a written motion to vacate along with the beginning of the case.
To vacate or to quash?
But maybe, I thought of it. It should be to vacate. I don't know. Maybe to quash the NTRP. I don't know.
The motion to quash. Would you like to file an oral motion to vacate all of the proceedings?
Yes, Your Honor. I'll move it this time to vacate the prior proceedings, in this case, based upon the fact that it was on a no involuntary plea, since she was pled to what she believed to be straight probation, which was an impossible or illegal plea. And that her decision to enter that plea was therefore based on, I would say, ineffective advice or ineffective information. So it's an involuntary plea.
So what I can do at this time is grant that oral motion to vacate as a writ under 11072. And so I'm going to grant that motion and treat it as a writ of habeas corpus under 11.072. I'm going to vacate all of the prior proceedings. And so we are now starting at step number 1. And so I'm going to reset the case for an announcement. Ms. Collier, make sure you stay in touch with Mr. Kimler. You need to be back at your next court date for an announcement, and we'll see where we go at that point. All right?
You mind, since you vacated, I don't need a motion to dispose of this entirely. It's been.
You shouldn't. It should be, everything should be vacated. And I'll double check if there's anything, but we'll do that. And I need a sticky note on that for an order. And Ken can help me kind of create an order for that.
Carrington appeared before Judge West after pleading guilty to evading arrest with a vehicle. Rather than imposing a prison sentence, the judge chose to give him a second chance by placing him on 5 years of probation. However, she made it clear that violating any probation condition could result in a prison sentence of up to 10 years. The hearing also addressed marijuana that had been found inside Carrington's vehicle. Although he possessed a medical THC card, Judge West reminded him that medical cannabis must only be used as prescribed and should never be kept inside his vehicle. Carrington agreed to every condition, and the court released him to begin his probation.